8, 7, 6, 5, 4, 3, 2, 1, 0.
Okay. You didn't want to play. We'll go right at it then. How is everybody on this fine, cold, snowy Monday evening? We got a few people in here. Glad to see you. We've been waiting all day for the release of Judge Gull and her attorney's responses to the defense's motions. And we got it. Cold, but no snow here. Woo! We're getting snow again. And yes, it's very cold. Eating chili and trying to keep warm. I'm going to be doing that later. After the show, I've got chili. So I'm going to be eating some too. How are you doing, Chris? Nice to see you. Jinx, Andrea, thanks for joining me. I wanted to jump on here and let everybody know how much snow are you getting. Just a dusting, Randy, but just enough to make it a nuisance. So we got snow yesterday. It's been snowing for about the past hour. Glad you're here, Randy. In fact, if you would like, hey, Jill, how's it going? If you'd like to join me up here, Randy, you certainly can. Otherwise, I can do that. Yes, my daughter made it back to Minnesota yesterday, so we are happy about that. Had a little issue with her car beforehand. How you doing, Jill? Glad you're here. All right, let's jump into this because there are a lot of pages. So, this was filed today at 3:41 p.m. State of Indiana, I like that, Rel, Richard Allen. So they are known as the relator versus Carroll Circuit Court and the Honorable Judge C. Gull, Francis C. Gull, special judge. So I'm not going to read all of this because there's a lot to get through. But look at this table of contents. Holy moly. Introduction, standard of review, argument. All of this stuff is listed. Conclusion, verified statement of word count, certificate of service. And if you thought that was a lot, here are the cases that they cited. There are a ton load of cases that they're citing, along with the statute, the Indiana Code, and the rules. Code of Judicial Conduct. I mean, it's crazy. So we're going to get started with the introduction. And let me tell you, they start out with a bang. It says, this court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying Realtors Counsel, respondent did not violate an absolute duty. Moreover, Realtors' remedies on appeal are wholly adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether Realtors Counsel withdrew or were removed, this court should deny this petition. Wow, what an opening paragraph, right? Realtors' petition further fails on the merits. Realtors' Sixth Amendment right to effective assistance of counsel outweighs his limited right to select his counsel. Respondent has discretion to remove Realtors' Counsel where, as here, the record supports the attorney Baldwins and Rozzi were providing ineffective assistance of counsel. Realtors' Counsel failed on multiple occasions to take reasonable steps to safeguard confidential case material, made extrajudicial statements that had a material likelihood of prejudicing the case, and provided false information to the court. Before removing Realtors' Counsel, respondent afforded Realtor with notice and opportunity to be heard through written submission as well as argument in chambers and on the record in open court. Realtors' request for this court to disqualify respondents fails because respondent alleges no bias or prejudice against Realtor or his current counsel. Realtor's lone assertion for respondent's removal is the trial court's ruling to disqualify Realtor's prior counsel. But a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. So basically what she's stating there is that this defense counsel, Rozzi and Baldwin, are, what's the word? Ineffectual counsel. They have failed to safeguard information on several occasions. And even though that Richard Allen wants them to continue being his counsel, she has disqualified them on the basis of they've failed to safeguard information, they've made extrajudicial statements that had a likelihood of prejudicing the case, and provided false information to the court. So let's see what they're talking about. Standard of review. The Supreme Court has the power by writ of mandate and prohibition to confine a lower court within the lawful jurisdiction. State L. Rel. City of New Haven versus Allen Superior Court. Writs of mandamus and prohibition are extraordinarily remedies which are viewed with disfavor and may not be used as substitutes for appeals. So they're giving more. This is where those cases come into play. This court will not issue a writ unless relator has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. So she's listing more cases here. Argument. Relator's petition fails the mandatory procedural requirements for seeking a writ. Relator does not have a clear and unquestioned right to have his counsel reinstated. This court has never issued a writ to reinstate counsel, whereas here the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, comprising the accused constitutional right to competent assistance of counsel. And contrary to relator's assertion, neither this court nor the United States Supreme Court has held that a trial court may remove an accused selected counsel in two circumstances only, where 1, counsel is not a member of the state bar, or 2, counsel has an actual conflict of interest. Citing more cases, relator does not have a clear and unquestioned right to the relief he seeks. To the contrary, this court in state, and this is another Jones versus Knox Superior Court, denied the relief relator requests here. In state Jones, the relator, who has been indicted for murder and rape, requested a writ of mandamus to reinstate his attorneys, whom the Troy court had removed. The court denied the petition. The court observed that it was generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the parameters of the authority here. This court's dictum in Jones does not provide relator with a clear, unquestioned right to relief or establish that respondent violated an absolute duty. Good God, reading this is crazy. Relator relies for the most part on cases from outside Indiana. See petition at and page 15 listing cases. But these cases are not binding on the trial court, much less do they impose on respondent an absolute duty to act. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Relator identifies no case from this court or the United States Supreme Court that affords him a clear right to an extraordinary writ for the relief he seeks. So basically what she's saying is that when they filed their motions, they didn't put any case laws in there. Relator's remedies by appeal are wholly adequate. All petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. Far too frequently writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits, which cannot be done. She lists another case. If relator believes that cases from other jurisdictions are persuasive in how respondent should interpret the Sixth Amendment, relator may present those arguments on interlocutory or direct appeal. Relator cannot file an original action to circumvent the normal appellate process. So basically what she's stating is that the defense has gone one step above by bringing this to the appellate court before they brought it to her court. Hope that makes sense. Because there is a process, just like chain of command in what we work, every day. You have your supervisor, then you have your manager, then you have this person, that person. That's what she's stating, is that they can't, just because they don't like things, they can't just take something to the appellate court and not bring it before her first and have her rule on it. Indiana's appellate courts, as well as other state and federal appellate courts, routinely consider Sixth Amendment challenges on interlocutory or direct appeal, including disputes about choice or removal of counsel. And here they go again. They're citing all of these different cases. And there's a ton of them. Relator cites Lada Hannah Harling and McKinnon in his petition and brief, all cases on appeal. Those cases defeat relator's assertion that his remedy available by appeal would be wholly inadequate. So it sounds like those cases that they did cite still haven't been decided, because they're still on appeal. Relator asked this court to use an original action to rule for the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. But this court will consider an extraordinary writ only when the law is settled and the trial court's duty is absolute. This court should decline relator's invitation to use an original action to alter Indiana law. Okay. Number 2, the trial court did not violate relator's Sixth Amendment rights by removing relator's counsel. Now remember, every time I say relator, that means Richard Allen. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will be inexorably represented by the lawyer whom he prefers. Wow. Okay. Respondent properly exercised her discretion to protect the relator's Sixth Amendment right to effective assistance of counsel by removing Baldwin and Rossi. As this court has explained, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of pauper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. The qualified right to choose one's own counsel must be placed against the backdrop of judicial discretion. And in each of these statements, she's citing cases that back up how she's interpreting things. The qualified right to choose one's own counsel must be placed against the backdrop. Okay, I read that. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. The Sixth Amendment's right to choice of counsel merely informs judicial discretion. It does not displace it. Wow. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. This court has explained that the trial court must be given latitude in its efforts to navigate the scala, and I don't know what that is, posed by the conflicting Sixth Amendment rights to counsel of one's choice and to competent counsel. Yeah. Well, so far, she's bringing out the big guns, right? We conclude that the trial court's discretion is necessary because the tension between these two important rights that must be resolved by the trial court, gross incompetence or contumacious conduct that cannot be cured by a citation for contempt, may justify the court's removal of an attorney, even over the defendant's objection. Cites another case. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice of its inception. Affirming disqualification of defense counsel on the grounds that the trial court has an obligation to foresee problems over representation that might arise at trial and head them off beforehand. The trial court retains the discretion to remove counsel to preserve an accused's constitutional rights to effective assistance of counsel and due process. Oops. Respondent acted well within her discretion to remove Baldwin and Rozzi over relatives' objections. The record supports that the trial court could reasonably conclude Baldwin and Rozzi committed multiple violations of the rules of professional conduct, compromised relatives' defense, and that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. Baldwin and Rozzi failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. Baldwin's friend and former employee, Mitchell Westerman, went into Baldwin's office conference room, reviewed confidential photos of the crime scene, took pictures of those photos, and shared them with at least one other unauthorized person. The photos leaked to the public, which promoted the police to investigate. An individual with whom Westerman shared the confidential photos committed suicide the night after police questioned him. Rozzi and Baldwin agreed to use Baldwin's conference room as a home base for confidential case materials. Rozzi understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. Okay, that is huge. That is something that we haven't heard yet. Because we were all wondering, including myself, why was Rozzi taken off the case? He didn't have anything to do with these individuals, right? He didn't have anything to do with the leak. Well, now she's stating why. She's stating that Rozzi and Baldwin agreed that Baldwin's conference room would be the home base. And Rozzi also knew about Westerman, who would frequently show up, and the fact that Baldwin would go over information of the case with Westerman. That is why she removed both of them. Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rozzi failed to timely report the leak to the trial court or prosecutor. The leak of crime scene photos was not the first time that Relators Counsel were involved in a leak of confidential case materials. In December 2002, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case that contained an outline of the discovery materials the state had provided to Baldwin. Baldwin apparently intended to send the email to Rozzi. Baldwin and Rozzi did not promptly notify the trial court or the prosecution of this leak. Number 3, Baldwin and Rozzi made extrajudicial statements that had a substantial likelihood of material prejudicing the case. Baldwin and Rozzi issued a press release on November 29, 2022. They included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed relators innocent. Baldwin and Rozzi did not limit their press release to information that Rule 3.6b expresses permits, nor did they confine the press release to information necessary to mitigate adverse publicity under Rule 3.6c. She's coming out with some big guns, you guys. Baldwin and Rozzi knew or should have known that the press release potentially violated Professional Conduct Rule 3.6, brief P-3, sup record, page 13. Moreover, at the time of the press release, Baldwin and Rozzi knew that the state had filed a motion for a gag order, which was pending before the trial court. Prior to issuing the press release, Baldwin and Rozzi assured the trial court that they did not intend to try this case in the media. Baldwin and Rozzi's decision to issue the press release prompted the trial court to issue the gag order until further hearing. Baldwin and Rozzi issued the press release knowing that the trial court would likely soon issue a gag order. Baldwin and Rozzi provided false information to the trial court. This is what I want to hear. On or about June 20th, 2023, the trial court held a hearing on Relator's motion to reconsider safekeeping order. At the hearing, the state presented evidence that clearly demonstrated the falsity of Relator's claim. On July 19, 2023, the trial court issued an order on the motion finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility. As a result of these events, the trial court became gravely concerned with Relator's rights to have competent, non-negligent representation. The record demonstrates that the trial court, based on the totality of circumstances, could reasonably conclude that counsel's representation of Relator fell objectively short of the prevailing professional norms, and that the counsel's deficient performances prejudiced the defense in violation of Relator's Sixth Amendment right to competent counsel. Yeah, she's putting them in there, boy. She is putting in every case law. I'm not reading them, but she is. They're in there, believe me. Yeah, you're right, Chris. All of a sudden, now that we're getting and hearing more, all of a sudden it's like, oh, she's had concerns a long time ago about these two and let them go. And then finally had enough. Okay. Counsel is ineffective where 1. Counsel's performance was deficient based on prevailing professional norms, and 2. The deficient performance prejudiced the defense. The professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. And respondents filing complaints against Baldwin and Rossi with the disciplinary commission would not have endured that Relator would receive competent representation through the remainder of the proceedings. That's huge. Just because she would have brought him up on the disciplinary commission, she doesn't feel that would have made sure that Baldwin and Rossi would have continued or would have started providing competent representation throughout the rest of the proceedings. The trial court's decision to remove Baldwin and Rozzi did not violate realtors' Sixth Amendment rights. The trial court, I forgot to put, hang on one second. Well, I'll just keep reading. You guys don't need to see all the words, but the trial court afforded realtors inadequate notice and an opportunity to be heard before removing his counsel. Realtor argues that removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. She's citing more cases. Realtor cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. In any event, the record confirms that the respondent, Judge Gull, provided realtor with ample notice that the trial court was considering disqualifying Baldwin and Rozzi before October 19th, 2023. And if you remember seeing those emails, she specifically told them to stop working the case. And she did mention disqualification in those emails. On October 11th, 2023, realtor wrote a letter to respondent requesting that Baldwin and Rozzi continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rozzi's disqualification. On October 12, 2023, Rozzi wrote a letter to respondent arguing why he and Baldwin should not be disqualified. October 12th. On the morning of October 19, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Realtor had adequate notice and opportunity to argue against respondent's disqualification of Baldwin and Rozzi. Baldwin and Rozzi also had the opportunity to proceed with the scheduled court hearing on October 19th, but chose to withdraw instead. At the October 31st, 2023 hearing, Baldwin and Rozzi further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record, including via Baldwin's counsel. Record volume PP, or pages 23 through 31. The trial court afforded realtors adequate process. Realtors' request for this court to order respondent's disqualification fails because respondent has shown no bias or prejudice towards relator, his current counsel, or his former counsel. Relator's assertion that respondent must be disqualified because she removed relator's former attorney is flawed. First, Baldwin and Rozzi no longer represent relator, and relator does not assert that respondent has any personal bias or prejudice towards himself or his current counsel. Second, on the meritus, relator presents no relevant facts supporting relator's assertion that respondent is biased or prejudiced against relator's former counsel. Judges have an affirmative duty to preside over cases unless disqualification is mandatory. She cites a case and says, see also Code of Judicial Conduct Rule 2.7. A judge shall hear and decide matters assigned to the judge, except when disqualification is required by Rule 2.11 or other law. Disqualification is mandatory in the rare instance that the judge displays a personal, individual bias against the litigant or the litigant's lawyer. She cites more cases. Moreover, as the commentary to the Code of Judicial Conduct emphasizes, a judge's unwarranted disqualification compromises the system of justice. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect for fulfillment of judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Code of Judicial Conduct Rule 2.7 commentary. The law presumes a judge is unbiased and unprejudiced. Garland versus State. And a few other cases. Judges are presumed impartial and unbiased. To overcome this presumption, relator must demonstrate actual personal bias. Actual bias or prejudice exists only where there is an undisputed claim of judicial bias or the judge has expressed an opinion on the merits of the controversy before. She lists a bunch of cases. Adverse rulings and findings by a trial judge are not sufficient reason to believe the judge has a personal bias or prejudice. The mere assertion that certain adverse rulings by a judge constitute bias and prejudice does not establish the requisite showing. Baldwin and Rossi no longer represent relator, and relator alleges no bias towards himself or his current counsel. Respondent removed Baldwin and Rossi from representing relator on October 31st, 2023. Respondent appointed new counsel, Robert Scremen and William Libredo, to represent relator. Relator is represented in this original action by Mark Lehman and Kara Weinke. Relator accuses respondent of exhibiting bias or prejudice exclusively toward Baldwin and Rossi. Relator never suggests that respondent is biased or prejudiced against relator or his current counsel. Given that Baldwin and Rossi are no longer counsel of record, relator's sweeping assertions that for all rulings going forward, the public will question the judge's impartiality, and that a new special judge must be appointed to restore the public's trust in the integrity of the judicial process, amount to blind speculation. Wow. Relator fails to show that respondent has actual bias or prejudice against Baldwin and Rossi. even if Baldwin and Rossi still represented Relator. Respondent has exhibited no actual bias or prejudice against them. Relator offers a scant 2 sentences to support his assertion that respondent has exhibited bias or prejudice. According to the Relator, respondent's finding that counsel were grossly negligent and publicly proclaiming that she had grave concerns about the representation warrant respondent's disqualification. I do have to say that that is weak on Rossi and Baldwin and whoever helped Richard Allen write this out, because she's absolutely right. You can't just say, I don't want the judge on my case because they took my attorneys away. Hi, Mother of Dragons. All right. But a judge's findings adverse to a party do not show or even imply bias or prejudice. Further, these findings do not demonstrate actual personal bias. Respondent did not state that she had grave concerns about Baldwin and Rossi personally. Rather, she had concerns only about the representation of Relator and his rights to competent representation. Respondent's legal findings regarding Baldwin and Rossi's representation are insufficient to overcome Indiana's law's presumption that respondent is unbiased and unprejudiced. The court should deny Relator's request to reinstate the trial date. Relator requested the continuance. Relator requests this court to reinstate the January 2024 trial date, but Relator's counsel requested the trial continuance because counsel will not be ready to try the case in January. Respondent did not violate an absolute duty of granting Relator's own motion. The court should deny amicus' request to refer appointment of a replacement counsel to the state public defender. Amicus Indiana Public Defender Counsel argues that the trial court's appointment of Relator's current counsel was procedurally defective, but Relator raises no objection to the respondent's process for appointing new counsel to replace Baldwin and Rossi. Amicus may make arguments in support of Relator's requests for relief, but the court should not entertain amicus' separate requests for relief. Neither IPDC nor Relator assert that Relator's newly appointed counsel, one of whom, as the IPDC notes, is Allen County's chief public defender, is incompetent. The IDPC merely claims that the trial court circumvented the county's comprehensive plan for public defender assignments. However, the trial court has discretion to appoint counsel other than counsel provided for under the board's plan when the interests of justice require. And she gives Indiana Code 334710A. The trial court's method of appointing Relator's new counsel did not violate Indiana law, the Sixth Amendment, or any other absolute duty under the law. Conclusion. Respondent, the Honorable Francis C. Gull, respectfully requests that this court deny realtors' verified petition for writs of mandamus and prohibition. Verified statement of word count. Pursuant to Rule 3B of the Indiana Rule of Procedure for Original Actions, undersigned counsel certifies that the foregoing contains fewer than 4,200 words as counted by the word processing system used to prepare the brief, otherwise MS Word. Undersigned counsel verifies that this brief contains 4,027 words. I certify that on November 27, 2023, I electronically filed the foregoing document using the Indiana Electric Filing Service. I certified that on November 27, 2023, a copy of the foregoing was served on the following persons: Kara Schaefer Wanke, Mark L. Lehman, Bernice Corley, Joel Schum, and Angela Sanchez. All right. So for those of you who are in here, let's have some discussion here. What in there surprised you about what the judge said? Anybody have any opinions? I think as we go back through that, she had concerns as early as 2002 about Baldwin and Rossi. We didn't see those concerns. She really didn't say anything. And she probably shouldn't have. She should have kept them to herself. But she lists multiple times in ways that she felt they were negligent. And I think the biggest thing that surprised me was how she answered the fact that Rossi also was taken off the case. Basically, it's because he knew that by making Baldwin's conference room their home base, that Baldwin and Westman would get together at Baldwin's office and discuss cases. So even though Rossi did not know these people that leaked the information, he knew this gentleman would go there and still agreed to make that the home base and have all the documents and evidence and discovery there at that home base. It's kind of worrying that they have apparently leaked info in the past, and yet they are able to practice law at the level to defend a death penalty. I would agree with you. And the fact that she says, the third thing that really kicked in for me was the fact that she said, even if she brought them up on disciplinary action, she does not think that that would make them start doing things the right way in order to go forward with the case. So she feels that even if disciplinary action is brought on them, they will continue to act the way that they have and do things unprofessionally. So it kind of makes sense now why she did what she did. She's stating that they had full notice in those emails when she told them to stop working on the case and that there was a disqualification or could be a possible disqualification, that they had enough notice. And that on the 19th, they should have known that that is what was going to be discussed and had their information and witnesses there to go forward. So from the sounds of it, I always thought there had to be a hearing to have due process. Apparently not. It shows to me that from the transcripts is not what she's saying. She seems to be saying the opposite of what was in the other papers. Well, have you seen the emails that she sent out? Let me see if I can. Oh, I had to disconnect my external hard drive. And they're on there. I think what we're going to need to do in another live is we're going to have to take a look at these emails very closely to see what was said and compare them to this. And this is the problem when something like this happens and you get the defense's part first of what they think is wrong and this and that. And then later on, the judge's thinking comes through. This is where you get the clash of information and, oh my God, the defense team, they were done wrong, and maybe not now. It's also sad because it will tar all public defenders with the same, yeah. It does not help. That is for sure. So what do you guys think as far as how long is it going to take the Supreme Court to come back with a decision? When given a chance to argue their side, Rozzi and Baldwin withdrew rather than challenge the yes. And that is huge because they could have gone to that hearing. Randy says not long. True Crime Investigates says they won't have a decision for a month. I'm hoping it's before a month. If it's as clear-cut as she's saying it is, shouldn't take that long to make a decision. But it depends on how busy they are too. So that, in that regard, it may take a month. Because Supreme Courts are always busy. Well, leave me some comments underneath the video. Let me know what your thoughts are on what she states in her response. It'll be interesting to see what everybody is thinking and saying. Is it as clear-cut now? Not really. Not now that we know she She had reservations about these two in 2022. Surely with it being a high-profile case, they will express check out this one so they can get on with the case. Yeah. You also have to remember she is defending her case just like any other defendant. Just because she says that's how it went down may not be how it went down. Right? This is her view, her side of things. What we heard previous was the defense's view and side of things. Now the Supreme Court has to look between the two and decide who's right. Just remember, had the crime scene photo thing not been made public, we wouldn't be here to exactly. Well, we wouldn't be here today, but does that mean they would have done something else wrong and we'd be here months down the road while a trial is happening? That's the biggest question. I mean, I wouldn't say that's the biggest question, but it's a reality. Is it a good thing this all happened before the trial started? In this case, I would think so, because I'm pretty sure that between all of us in this community and the families, we only want one trial. We don't want a trial and then have something happen and have to have it retried. Hi, Lollipop. We just went over the judge's response. But it's crazy. You know, it's very crazy, and we just got to wait now. We got to be patient. Some more. That's all this case requires of us, is more patience. And we'll have to wait for the decision. Judge Gull wasn't alone in calling for the High Court to throw out the petition, as Indiana AG Todd echoed. Oh, okay. Wow. I've heard that these new attorneys have issues too. So it should be interesting. Should be interesting. Where did you send it? Oh, wait. I think I found it. The Attorney General agrees with the judge. Oh no, Lollipop. I hope you got that figured out and straightened out. That's never fun. Let's take a look at this article. What is his name? Rakita? Rakita echoes Delphi judge in asking Supreme Court to throw out petition calling for her removal. Judge Fran Gull sent a petition to the Indiana Supreme Court calling on her to be removed from the Delphi murder trial should be thrown out due to the defense not using proper legal avenues in order to seek their end goal. I think that is what's going to get them in the end, is the fact that they did not take proper go through the proper channels. Gull wasn't alone in calling for the High Court to throw out the petitions, as Indiana Attorney General Todd Rokita echoed many of Gull's same sentiments in separate filing that also asked the court to reject the petition. Wow. Both Gull and Rokita called the writ of mandamus filed with the Indiana Supreme Court the legal petition that not only called for Gull's removal, but for the reinstatement of accused murderer Richard Allen's original defense team improper, with both stating that Allen should have pursued an appeal if he thought Gull was abusing her power by removing his original defense team. Wow. Richard Allen wants Baldwin and Rossi to be his representation. No attorney is liked when they're prosecutors. Yeah. So it says, Rokita argued that a writ of mandamus was inappropriate for pursuing the reinstatement of legal counsel, and the appellate process is the adequate and preferred way to present these arguments, not a writ of mandamus. And Rokita pointed out that Allen didn't appeal these actions or file a motion to disqualify despite having the chance. Interesting. I agree with that. I agree. Lollipop says she thinks those leaks were hoping for a mistrial. Yeah, but just because there's a mistrial doesn't mean that he would get out of jail. Does it? Because I'm thinking that they would at least put a bond on him, and it's going to be a high bond. Can he pay it? If he can't afford to pay an attorney, he's not going to be able to afford a bond. So it'll be interesting. Now we wait. We wait to see what happens with the Supreme Court. Yeah, I noticed that my internet signal is not very good. Not sure why. But all right, everybody. Yeah, they would have to keep him on. They would have to do a bond if they were going to let him out on a mistrial, I would think. But all right, everybody. I'm going to end this for today. Like I said, leave a comment on your thoughts below the video. It's definitely going to be interesting to see what the Supreme Court says and who they agree with. What is this? The Knot Group, the Unraveling, said today on Discord they're trying to raise funds to hire Richard Allen. Oh, yeah. Yet they don't support the kid killer. Interesting. I will be back later this week. I've got some projects in the works, and tonight I am going to be trying to upload the next episode of Tabitha's story. So, probably Wednesday or Thursday, I will be back live. All right, everybody, have a good night, and I will see you soon. Bye.